She's lying. The woman's voice cracked through the courtroom like glass shattering. Gasps rippled across the gallery. The judge didn't flinch. Double quotes, Ms. Delaney. He said evenly, "You will wait for your attorney." But she was already on her feet. "You've been against me since day one." Her attorney grabbed her sleeve. "Sit down." She didn't single quotes T. She pointed directly at the bench. "You remember me, don't you?" The courtroom went still. The judge's expression tightened just slightly. Security shifted near the walls. "If you continue this behavior," the judge warned, "I will have you restrained." But she took one step forward, then another, and that's when the bailiff moved. Before we go further, subscribe, because what looks like a courtroom meltdown is about to turn into something far more complicated than anger. Her name was Marissa Delaney. 30-4. Charged with felony obstruction and evidence tampering. The state claims she interfered with a fraud investigation tied to her employer, a private medical billing company accused of falsifying insurance claims. Marissa claimed she was a whistleblower. The prosecution claimed she destroyed documents, and presiding over the case, Judge Harold Benton, a man known for rigid courtroom control. "Ms. Delaney, return to your seat," he said again. Her breathing was uneven now. "You already decided," she said. "That is not accurate. You denied every motion my attorney filed." Her lawyer whispered urgently, "Stop." But Marissa's eyes were locked on the judge. "You think I don't recognize you?" That caught everyone's attention. The prosecutor frowned. The judge remained composed. "Recognize me from where?" he asked calmly. Her jaw tightened. 8 years ago, family court." A murmur moved through the room. The judge's posture shifted. "Slyly, proceed carefully," he said. "You ruled against me," she continued. "You gave my ex full custody." Her voice cracked. "And now you're ruling against me again." The courtroom air felt charged. The prosecutors stood slowly. "Your Honor, relevance." The judge held up a hand. "I will address it." He looked directly at Marissa. "I have presided over thousands of cases. I do not recall yours specifically." Her laugh was sharp and bitter. "Of course you don't." Security stepped closer as she took another half-step forward. The bailiff spoke quietly. "Ma'am." But she wasn't done. "You believed him," she said. "You believed everything he said about me." The judge's voice lowered slightly. "This is not the appropriate forum." "It never is," she shot back. Her attorney stood abruptly. "Your Honor, my client is under significant stress, but as a parent." The judge's tone was firm, but not hostile. "Ms. Delaney, if you approach the bench again, you will be restrained." For a moment, it looked like she might ignore him. Her hands were shaking, her breathing shallow. The gallery was frozen. Even the jury, who had been dismissed for a procedural hearing, sat in stunned silence. Then she said something that shifted the energy entirely. "You didn't just rule against me." She swallowed. "You told me I was unstable." The judge's eyes sharpened. "I never make medical declarations from the bench." "You said I was emotionally volatile." "That was based on testimony presented." She took another step, and that's when the bailiff grabbed her arm. Not violently, but firmly. "Ma'am," she jerked instinctively. "I'm not attacking anyone." But from the outside it looked exactly like escalation. The prosecutor spoke. "Calmly, Your Honor. The state requests removal." The judge paused, measured the room, then looked back at Marissa. "Release her." The bailiff hesitated. "Release her," the judge repeated. The grip loosened. Marissa stood there, breathing heavily. "This court will take a brief recess," the judge announced. The gavel struck, but he didn't leave immediately. He looked at her, not with anger, with scrutiny, and something else, recognition. Because as the courtroom began to clear, something had shifted behind his eyes. He did remember something. Not her face, but the file, the medical evaluation attached to that custody case, and the name of the psychiatrist who had testified, a name that now also appeared in the fraud investigation, tied to her employer. "If you think this is just about courtroom emotion, you're wrong." The courtroom did not fully empty you during recess. No one wanted to leave. The tension was too thick. Marissa stood near the defense table, breathing slowly now, her attorney whispering urgently in her ear. "You cannot do that again," he said. "If you rush the bench one more time, you will be held in contempt." "I wasn't rushing," she muttered. "I was trying to make him remember." Across the room, Judge Benton remained seated longer than usual. He had not exited through the private door behind the bench. Instead, He was reviewing something on a tablet handed to him quietly by his clerk. The prosecutor noticed. That was unusual. When the judge finally stood, he did not look at Marissa, but he didn't look neutral anymore either. He looked thoughtful. 15 minutes later, everyone was called back to order. All rise. The judge returned to the bench. The air had shifted. This was no longer just about obstruction charges. Before we proceed, Judge Benton began. The court has reviewed certain prior records connected to Ms. Delaney. Marissa looked up sharply. Her attorney stiffened. Your Honor, the prosecutor said cautiously. The judge folded his hands. Ms. Delaney referenced a prior custody case presided over by this court 8 years ago. I have confirmed that I did, in fact, oversee that matter. Marissa's fingers tightened around the edge of the table. The prosecutor spoke carefully. Your Honor, with respect, prior unrelated matters may now be related. The judge interrupted calmly. Silence fell. Marissa's attorney leaned forward. Related how? The judge's voice was steady. The psychiatric evaluator who testified in that custody hearing, Dr. Marty Kellerman. Marissa's breathing picked up. The prosecutor's jaw tightened slightly. That same individual, the judge continued, is listed as a consultant in the medical billing company under investigation in this current case. A ripple of murmurs filled the courtroom. The judge tapped his gavel once. Order. Marissa's voice was barely above a whisper. I told you. The prosecutor regained composure. Your Honor, Dr. Kellerman is not on trial here. No, the judge said evenly. But if there is potential overlap affecting credibility, this court must acknowledge it. Marissa's attorney stood. Your Honor, are you suggesting conflict of interest? I am suggesting possible bias in prior testimony, the judge replied. The prosecutor interjected. That testimony was evaluated and admitted at the time. And yet, the judge said quietly, if that testimony influenced a custody determination, and the same individual is financially tied to the present employer, we cannot ignore that coincidence. The courtroom felt electric. Marissa wasn't shaking anymore. Now she looked focused. You see it now, she said softly. The judge met her eyes. This court does not operate on emotion, he said, but it does operate on evidence. If you're starting to see the layers unfold, subscribe now. Because this isn't just about a courtroom outburst, it's about whether one professional manipulated two separate legal systems. The prosecutor stood again. The state's case is that Ms. Delaney accessed secure billing records and deleted data relevant to an insurance fraud probe. Marissa's attorney nodded. Double quotes. And our position remains that she preserved evidence of illegal overbilling and was silenced. The judge leaned back. Bring up the digital audit logs. The prosecution projected a timeline. Access at 9:42 p.m. Deletion. At 9:44 p.m. Marissa exhaled sharply. You're skipping the download, she said. The prosecutor ignored her. The judge did not. Counsel, he said calmly, was there a data export immediately prior to deletion? The prosecutor hesitated, just slightly. Yes. Was that export reviewed? It was incomplete. Marissa's attorney stepped in. Incomplete, because it was interrupted by company remote access. The judge's gaze sharpened. Cliff's Clay. Marissa spoke before her attorney could stop her. They locked me out. Miss Delaney, her lawyer warned, but the judge raised a hand. Let her answer. Marissa swallowed. I downloaded internal communications. Emails between Kellerman and the CFO. They were discussing modifying patient severity codes to increase insurance reimbursement. The prosecutor objected immediately. Unsubstantiated claim. Marissa didn't back down. They flagged patients as higher risk when they weren't. The judge's voice was calm but intense. Do you possess those emails? Yes. We're in a cloud archive, not on their system. The prosecutor looked visibly unsettled for the first time. Your Honor, this is a diversion tactic. The judge leaned forward, awed his exculpatory evidence. Silence. Then the judge delivered the line that shifted the entire hearing. This court will not proceed with sentencing or evidentiary ruling until the alleged communications are subpoenaed. The prosecutor objected again. Your Honor, denied. The gavel struck once. Marissa exhaled slowly. Her eyes welled, but not from panic this time. From relief. The judge looked directly at her. You should not have approached the bench. She nodded. But if what you are alleging is accurate, then this case may require re-evaluation. The courtroom atmosphere had transformed. Moments ago she looked like a defendant losing control. Now she looked like someone who may have been cornered for speaking up. The prosecutor gathered his files. More stiffly than before, Your Honor, the state will comply. The judge nodded. This matter is continued pending evidentiary review. He paused. And Ms. Delaney, further disruptions will not be tolerated. Yes, Your Honor. Her voice was steady now, not defiant, focused as the gavel fell, and the courtroom adjourned again. The narrative had flipped. She hadn't attacked the judge, she had challenged him, and for the first time, he had listened. The courtroom was fuller than before. Word had spread. What was supposed to be a routine evidentiary continuation had turned into something much larger. Observers filled the gallery. 2 additional attorneys sat behind the prosecution table, corporate counsel for the medical billing company. Marissa noticed immediately. They're scared, she whispered to her attorney. Or cautious. He replied quietly. Judge Benton entered. The room rose. He sat, expression composed but firmer than before. This court reconvenes to review subpoenaed digital communications relevant to the matter of State v. Delaney. Leclerc handed up a binder. The prosecutor stood. Your Honor, the state maintains that even if these communications exist, they do not negate the defendant's unauthorized system access and deletion of company property. Marissa's attorney stood immediately after. If the deletion occurred while preserving evidence of criminal fraud, the legal characterization changes entirely. The judge nodded once. Display the communications. The courtroom monitor flickered to life. An email chain appeared. From Dr. Martin Kellerman to CFO Ridgeway Medical Billing Subject. Adjustment protocol. The prosecutor shifted. Marissa's attorney said nothing. The judge read silently for several seconds, then aloud. Ensure severity coding, reflects reimbursement optimization strategy. Flag borderline cases upward when documentation allows interpretation. A murmur swept through the room. The judge's eyes moved lower. Regulatory risk manageable. Internal audits can be structured. The corporate attorney stood quickly. Your Honor. Taken out of context. Sit down. The judge said evenly. He continued reading. Another email. From CFO to Kellerman. Whistleblower risk minimal. Delaney flagged for monitoring. The courtroom went silent. Marissa didn't blink. The judge leaned back slowly. Continue. A third message. Custer's history suggests credibility vulnerability. That line landed harder than the others. Marissa's hands trembled, but she didn't look away from the screen. Her attorney spoke softly. Your Honor, this establishes motive. The prosecutor's voice was controlled but tense. It establishes internal concern, not criminal fraud. The judge looked at him. Counsel. Severity coding manipulation tied to insurance reimbursement may constitute federal offense. The prosecutor didn't respond immediately, because he knew that was true. If you're watching how quickly power dynamics shift inside a courtroom, subscribe now, because this moment, when documentation replaces accusation, is where truth changes everything. Judge Benton addressed the corporate counsel. Is Dr. Kellerman present? A pause. He is not, Your Honor. Why? He was not subpoenaed. The judge's tone hardened slightly. He will be. Cliff Avil tapped once. Clerk, issue appearance order. Marissa exhaled slowly. The prosecutor pivoted. Your Honor, regardless of these emails, Ms. Delaney accessed restricted servers and deleted internal files. The judge looked at the forensic log again. He'd display the access sequence. The timeline appeared. Login at 9:42 p.m. Download at 9:43 p.m. Deletion at 9:44 p.m. Now an additional detail was highlighted. Remote administrator. Login at 9 hours 44 minutes and 8 seconds p.m. Marissa's attorney stepped forward. That's a lot. The judge narrowed his eyes. Administrator credentials used. Corporate counsel stood again. Standard automated security protocol. The judge's voice was calm. Automated protocols do not usually activate 8 seconds after deletion. Silence. Marissa spoke carefully. They wiped it. The prosecutor interjected. There is no proof of wiping. The judge tapped his pen lightly. There is proof of administrative override. He looked at the prosecution. Has the state investigated the company's billing practices? The prosecutor hesitated. Preliminary review. The judge's tone sharpened. Has the state reviewed these emails prior to charging Ms. Delaney? A longer pause. No, Your Honor. That admission changed the room, because it meant something critical. The investigation had been one-directional. focused on her, not on the institution. Marissa's earlier outburst suddenly felt less like instability and more like desperation. The judge folded his hands. This court will now address the obstruction charge in light of newly admitted evidence. The gallery leaned forward. Obstruction requires intent to interfere with lawful investigation. He looked at Marissa. If the defendant believed she was preserving evidence of unlawful conduct, he let the sentence hang. The prosecutor spoke carefully. Belief does not grant immunity. No, the judge agreed, but it reframes intent. He paused long enough for every person in the courtroom to feel it. Double quotes Ms. Delaney. Did you report your concerns prior to accessing the server? Yes. To whom? Internal compliance. And the response? Silence. Did you contact external authorities? Yes. 2 weeks before this. The prosecutor stiffened. Documentation. Her attorney produced a copy. Whistleblower submission form. Time-stamped. Filed. The judge examined it. State, were you aware of this filing? No, Your Honor. The courtroom shifted again. Now it wasn't just about billing codes. It was about investigative oversight. The judge spoke slowly. This court cannot ignore the appearance that Ms. Delaney's credibility was undermined. Previously in a custody case through testimony from an individual, now financially tied to the organization, under scrutiny, he looked directly at Marissa. You were labeled unstable. She nodded, double quotes, yes. Based on Dr. Kellerman's testimony. Yes. And now that same individual appears to have influenced the professional environment surrounding this criminal charge. The judge's gaze moved across the courtroom. That is troubling. Corporate counsel rose again. Your Honor, this line of reasoning is speculative. The judge's voice remained level. It is procedural caution. He turned toward the prosecution. The obstruction charge is hereby dismissed without prejudice pending federal review of the underlying billing practices. The words landed. Heavy. Marissa's breath caught. Her attorney exhaled sharply. The prosecutor stood stunned for half a second, then composed. Understood, Your Honor. The judge wasn't finished. This court further orders referral of Ridgway, medical billing for independent audit, and forwards evidence to the Attorney General's office. A collective murmur swept the room. Marissa closed her eyes. For the first time since the hearing began days earlier, she wasn't fighting. She was vindicated. The judge looked at her carefully. You should not have disrupted this courtroom. No, she said quietly. But, he continued, sometimes disruption forces review. He paused. I do not recall the details of your custody case, but I do recall relying on professional testimony. He inhaled slowly. If that testimony was influenced by factors now called into question, that concerns me. Marissa's eyes welled, not from anger, from release. Court is adjourned, he said. The gavel struck, but this time the sound didn't feel punitive. It felt corrective as people began filing out. Reporters whispered near the back. Corporate counsel moved quickly toward the exit. The prosecutor remained thoughtful. Marissa stayed seated for a moment. Her attorney touched her shoulder. It's over. She shook her head slightly. Not yet. He looked confused. The audit, she said. It's bigger than me. He smiled faintly. Yes, it is. As she stood, Judge Benton remained on the bench for a moment longer. He looked at the emptying courtroom, at the system he represented, and at the file still open in front of him. 8 years ago, he had trusted expert testimony. Today, that trust had been tested. Justice, he realized, is not static. It requires correction. If you saw how quickly perception shifts when documentation replaces accusation, subscribe now. Because courtroom stories aren't about chaos, they're about accountability. Marissa walked out not as someone who attacked a judge, but as someone who forced the system to look twice. And sometimes, that's the most dangerous move of all.